Well, welcome everybody. I'm Louis Lowe. I'm a partner at Foley and Lardner in Silicon Valley, joined by my esteemed colleague Catherine Zhu, and together we help companies go from garage to global. And in the last several years, we've seen this phenomenon of companies tokenizing their businesses, tokenizing their cap tables, and now tokenizing their content on the blockchain and bringing that to the web in this new phenomenon that we call Web3. And so today we're going to get together and talk to you about how to think about legal matters when mapping out your NFT marketplace. But before we get started, I thought it'd be great if, Catherine, you could introduce yourself and move the slides forward.
Thanks, Louis. I think, let me know if we're not seeing the right slide, but we are on the slide with our profiles.
Well, here we go.
Yep. Hi, everyone. My name is Catherine. I am an attorney at Foley and Lardner in Silicon Valley, working with Louis on various emerging technology companies, including NFT companies. I've started working in this space for almost a year now, and we've done a lot of work with marketplace providers, in particular NFT marketplace providers. So happy to engage in a lively discussion today about that and other related topics. Louis, I'll let you introduce yourself.
Thank you so much, Catherine, and what I enjoy most about being a lawyer is helping companies translate their ideas into businesses. And I started my career on Wall Street at a New York law firm practicing securities laws. And back in those days, filings with the SEC were made on paper, and the World Wide Web was in version 1.0. And today we're in version 3.0 as businesses attempt to interact with customers in decentralized ways directly without intermediaries. And they look to monetize the content, the data, and the business that they're doing using the blockchain, sometimes even tokenizing their cap tables. And so today, moving to the agenda slide, Catherine, we thought we would really set the stage for why would you want an NFT marketplace, and then talk about the securities law issues that are implicated by that, the other regulatory issues, and then Catherine's going to dig into commercial IP and privacy constraints. And so moving to the next slide, we really just wanted to set the table and talk to you about what is an NFT. And obviously, there are all sorts of different types of tokens that we learned during the summer of coin in 2017. There are utility tokens, there are securities tokens, there are fungible and non-fungible tokens. And really, an NFT is a non-fungible token because it is unique. It represents something that can't be interchanged with any other token. It's minted or created directly onto the blockchain, and it contains immutable data stored across a distributed ledger, meaning that no one can unilaterally modify the record of ownership associated with it, nor could anyone else make a copy of it. It's unique, it's uncorruptible, it's unfalsifiable, it's indestructible, eliminating the need for any outside authentication like you see in the world of art or other collectibles. And really what we saw at the outset of the pandemic was the world working from home. We saw massive government stimulus. We saw cash being flooded onto financial markets. And we saw entrepreneurs look to create new businesses and monetize. And for many years, artists, and I just think of musicians, really can't sell albums anymore, and they couldn't go on tour and do concerts anymore. And so really they were stuck, having created these libraries of amazing content that they were really having trouble monetizing. And so NFTs were the answer. You had sports figures who could no longer play in live events, um, and monetize their personal brands. And you saw this in the world of art, where you couldn't go to an art show anymore, or into a gallery, and so all of this came online, and you came together with these movements of content creators, with new business models of content monetization, and it was the birthplace of the NFT marketplace. And together with my partners at Foley and Lardner, we really enjoyed being being there for this phenomenon, and to help our clients bring these to life. And Catherine, you've had some just fascinating experiences working with sports franchises and artists, and people across the value chain. And moving to slide 4, I'd love to hear from you about why you think NFTs are such a big deal.
Yeah, I'm happy to discuss that, especially in light of the work that we've done over the past year for some big names in the space. So I think just from a market standpoint, NFTs have really entered into the mainstream consciousness. I think before 2021, blockchain really was still more of kind of a fringe topic. There wasn't as much, venture capital interest, or people in the mainstream weren't really talking about it. And then in 2021, we really did see an explosion of NFTs. And I think it was through this explosion that we've really seen blockchain as a technology and Web3 as a future really entered the mainstream awareness. And a lot of the reason the NFTs became so popular was because they really provided the technology to enable creators to monetize their content in different ways. So I think before NFTs, right, there was a lot of middle parties. For example, if you were a musician and you wanted to create an album, right, you would have to go through a lot of different parties, and by the time the album actually got produced and sold to people, as a musician, you would only have a very small chunk of that sale revenue. And I think the NFTs, and this has been a larger trend in technology, with the rise of platforms like TikTok and YouTube, but the NFTs really did provide another way for content creators to engage directly with their fans and their audiences. So that really was the point of inception, I would say, for the mainstream kind of coming into using this blockchain technology, because we have seen over the past year or so a lot of really big brands start to look into NFTs as a way to increase their brand awareness and their engagement with the public, and the public perception of their brand. And so, we have a lot of different examples on this. I think one really prominent one was when Coca-Cola minted a virtual puffer jacket on OpenSea, which is like it's like a walking, I wish maybe, I don't think we have, last time I tried to pull it up, we ran into technical difficulties, but it's like a walking puffer jacket that has the Coca-Cola color scheme and logo on it. And if you buy the puffer jacket, you can actually wear the puffer jacket in Decentraland, which is a open access virtual reality platform. So, that type of engagement by a brand with this kind of technology and, virtual reality, that's becoming an increasing trend. And then we've also seen NFTs, in addition to avatars for virtual reality, we've also seen a lot of NFTs come up in the fine art and collectible space. That kind of, I would say the watershed moment was really towards the beginning of last year, when a Beeple art piece was sold by Christie's auction house for $69 million, which was really unprecedented, I think, for an NFT, literally a JPEG image, an NFT of the JPEG to be sold for that amount of money. And since then, we've really seen NFTs kind of explode in the fine arts space. And we've seen musicians get into this. We've seen different artists get into that. And also sports teams. So Foley and Lardner and me personally, with some of the other attorneys at Foley and Lardner, have helped the Bucks as the second NBA team and the Jazz as the third NBA team do their respective NFT drops. And it was really seen as a way to, create this digital collectible as a way to further engage with their fans. And I would say both were relatively successful. And we've seen it also.
Catherine, what did they drop?
That's a great question. So the Bucks did a more traditional drop, like the Warriors did, where they released a digital art collectible commemorating, for the Bucks, was the 1971 championships that they had won. And this collectible, it's similar to the Beeple one that Christie's sold, in that you would buy the NFT representing the underlying asset, and then you would hold that, and that would be worth something as a digital collectible. The Jazz drop was a little bit different. They didn't do a traditional collectible. Their NFT was an access pass. So if you bought the NFT, there were different tiers of access that you could buy. So you could buy an NFT representing a different access pass, and then depending on the tier of access pass you got, you would be able to participate in a virtual reality event that we engaged or they worked with Spatial to provide. So they created a 3D locker room, and each of the people who bought the NFTs could enter the locker room virtually, and then the owner of the Jazz would be there also virtually for a virtual conversation tour and fireside chat. So the Jazz NFT, and I think the two examples just goes to show, how diverse the application of NFTs are. Like, you can have the digital collectible way of engaging with your fans, and that's been really popular with brands and sports teams, but you can also use the NFT as a token for access, or like an avatar in the Coca-Cola example. So there are a lot of different ways to cultivate the engagement using the NFT technology.
So it sounds like we saw different use cases, that you've outlined. One is, content creators like artists using traditional auction houses like Christie's to auction off unique pieces of art, but I guess the digital rendition. And so I guess the owning a Damien Hirst painting, for example, that you could buy off of the Henny marketplace would have value and appreciated value because you have a unique copy of it. But then you also saw, it sounds like, brands like Coca-Cola trying to communicate with their customers by creating NFTs with that represented virtual goods, and then it sounds like we've also seen artists, musicians do the same thing. And so, Catherine, when you have when you want to go to market with your NFT, does that mean you're a marketplace, or do you want to be a marketplace? And tell me the difference in business model between being a content creator, and being a marketplace.
Yeah, those are really great questions. So there, and we'll go on the commercials contracting slide into more of the legal aspects of this, but there are a lot of parties typically in NFT space. So as Louis, you mentioned, right, there are the creators, there are a specific segment of participants in the ecosystem. There's the marketplace provider like OpenSea or Coinbase, for example, with their NFT marketplace, and they're providing the marketplace upon which the parties can transact. And then the third bucket is kind of the buyers. And these are, individuals, so people kind of like generally individuals buying and trading NFTs on those marketplaces. But I think within each of those different buckets, you can actually have more parties. So for example, at the seller slash creator level, there are different business models you can implement. So, I mean, in kind of the vanilla one, it would just be like an individual artist or individual seller minting their piece, putting it on the marketplace, selling it to the buyer. But you can really get creative with that business model, especially, you know, at the seller level. Like you can maybe, we've seen examples where companies, galleries have presented themselves as the seller, but they will actually engage an artist or a headliner or some other designer to create the NFTs. There might be collaborations that they're doing on these drops. There could also be, you know, they can also help curate the collection to a certain extent. So there's, you know, you can really transact within each segment as well. And then, you know, for the marketplace, there's a platform provider like OpenSea, but a lot of times if somebody wants to do a drop and they want to have their own NFT sale, Coca-Cola, for example, or even the Bucks and the Warriors, they're not going to go out and create an NFT marketplace themselves. They usually typically partner with one of these NFT marketplaces. I think for the Jazz, it was Rarible, and for the Bucks, it was OpenSea. And there's a whole slew of other marketplaces out there who, you know, it could be a viable business model just to be the preferred provider for a lot of these brands who are trying to get into the space. But there's also transactions that are occurring at the micro level at the in the middle part where you're trying to, you know, provide the platform for these transactions. So I would say the short of it is there are just a huge variety of business models that can that we've seen arise, and there's just almost an unlimited potential for how you can kind of, because there's so many parties and so many different ways to transact, there's a lot of potential for innovative business models to come out of this.
I love it. I love it. Well, let's put a pin in that. On our next slide, we've got some terminology that we've set out just to create some baselines, and you'll see that in the materials that follow this presentation. You know, we wanted to cover the common legal issues that arise when creating a marketplace, and you know, the first of which are the securities laws issues, which are implicated by the creation of the token itself, and then how that token is traded and where it's traded and how the payments flow, and other regulatory considerations like anti-money laundering and countering terrorism. Next, we're going to cover some privacy concerns. Then I think Catherine's going to go right into the commercial transactions that occur between the content creator, the marketplace, the payment processors, and the end users in primary and secondary transactions. And then finally, we're going to wrap up with some IP. And so circling back to the creation of a token, you know, the simple example which Catherine and some of my other partners hosted in a separate webinar about minting and NFTs. You could go to a place like OpenSea. You could upload some sort of intellectual property that's yours, and yours, and on that platform you can turn it into a non-fungible token. It can be minted, and then it can be listed for sale, so that OpenSea is both a place where an NFT can be minted, but it's also a place where there's a marketplace for both primary sales and secondary sales. And I raise the difference because they're in the primary sale, it's being sold by the content creator, and in the secondary sale, it's being sold or listed for sale and offered and sold by a holder in the first instance to a holder in the second instance. And so back in the summer of coin in 2017, when there was the first wave of initial coin offerings where the tokens were in fact fungible, they were currencies, money. that was going to trade and could be used to buy and sell goods in the stream of commerce. It was a subject of great controversy as to whether those tokens that were fungible were items of currency, whether they were commodities, whether they were in fact securities, or just items of property. And the quintessential legal definition of a security came from the Supreme Court in a case called Howey. And as applied to digital assets, it's going to call for the regulation of a token as a security if it constitutes an investment contract. And if it is an investment contract, then it will be required to be registered under the Securities Act of 1933, unless it is offered and sold under an exemption from that registration. So let's unpack that investment contract question. A digital asset is going to be an investment contract if there is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. And where digital assets have fallen into the specter of regulation is when they're used to raise capital, where the proceeds of that token sale are used to build the network. And so that really is the danger zone where many of the tokens that were issued in 2017 were criticized by regulators and courts alike as having been, in fact, investment contracts that were sold not in compliance with registration and not in compliance with some exemption from registration. And in subsequent statements by the Securities and Exchange Commission, we learned from then Director of Corporation Finance, Bill Hinman, that Bitcoin was not viewed as a security by the SEC because it had been deemed so useful and it had such a utility in the stream of commerce that the Securities and Exchange Commission did not view it as such. However, the Commodities Futures Trading Commission, or the CFTC, did view it, in fact, as a commodity, which put it within its purview of regulation. And then finally, the tax bar has been very clear that any kind of a token, whether it's fungible or not, whether it's a security or utility, is an item of property that will be taxed as such, so that if you make a gain in the purchase and sale of a token, that will be taxed either as a short-term or long-term item of gain. And so we've seen in recent years a real crackdown by the Internal Revenue Service in the US and corollary revenue authorities in other countries looking for a share of the gain. So when setting up your NFT marketplace, you really want to make sure that sales of NFTs are not used to build the network, that the network has already been built. And so therefore, when setting it up, you really need to use the tried and true methods of raising capital, which are going to be regulated as securities. And so the typical instruments of simple agreements for future equity are safe, convertible notes, sales of common stock and preferred stock. Use the proceeds there to create your marketplace. And then once that's built, bring content creators to your site to mint tokens and then list them for sale, both to primary purchasers and secondary purchasers in a resale transaction. Now, if you haven't ensured that your NFT is not a security in the first instance, you're going to have a problem listing it for sale, because you would then be an exchange, and your marketplace would need to be registered as a national securities exchange, which is a very lugubrious process that none of the exchanges have complied with. even those that have chosen the path of regulation to build their businesses. Before I hand it back to Catherine to talk about the more commercial aspects, the other areas where token creators and resellers and marketplaces can get in trouble with regulation are the various KYC and CFT regulations, where governments around the world want you to know your client and counter the financing efforts of terrorists. And so there are a number of different technologies and vendors that are out there to help you maintain compliance, and it's really critical that you design in KYC and CFT compliance from inception in your marketplace. The Bank Secrecy Act of the United States contains additional responsibilities for marketplaces relating to KYC and CFT. Anti-money laundering rules in the US, the UK, and other jurisdictions around the world are also critical to comply with. And finally, an often forgotten area of compliance are money transmitter laws. And when you're making a marketplace and you're listing NFTs for sale, somebody in the stream of commerce is going to have to take in a payment from a purchaser and then distribute that payment to the content creator and the other recipients of those flows, and that can make you a money transmitter, which is governed by federal law in the United States, state law, and in some areas even city laws. And it's a complex registration process that I am told anecdotally can take anywhere from 6 months to 2 years, and can require a budget of in excess of $1 million to get completed. And so, again, making sure that you're clear on who's going to be taking payment and who's going to be processing those payments is a critical part of creating your NFT marketplace. Catherine, I wanted to turn it back over to you to talk to us about the contracting considerations in creating an NFT marketplace, because of course an NFT at the core is a smart contract. Catherine?
Yeah, that's a great starting point. So definitely smart contract and those in the audience can definitely refer to that slide of common terminology later on if you need to refresh what a smart contract is. But just really briefly, a smart contract is a code protocol that executes upon the fulfillment of a certain set of conditions, and usually those conditions are based on it's called an oracle, which is a data feed that will feed data into the smart contract, and then if certain conditions are met, then the smart contract will execute a certain prescribed protocol of actions. And a lot of the transactions that take place on an NFT marketplace, that happens through smart contracts. So the smart contract is programmed, for example, once you mint an NFT, to write that NFT onto the blockchain as an immutable record. If there's a sale that happens, the smart contract is going to execute on that from a record of ownership standpoint, and can also kind of allocate the proceeds from that sale in the manner that has been pre-programmed. So it does act as a quote unquote contract in that sense, but I think it's important not to conflate a smart contract with a real contract, because a smart contract, at least as of today, we don't have a law or guidance that says, hey, a smart contract is equivalent to an actual legal contract of the four corners of the document. So we don't have that. So the smart contract can implement what is agreed upon in a real contract, like if you agree to a certain revenue split or agree to certain things. But a smart contract by itself is not a contract. It is just a way to execute, and probably a good technical, way of enforcing a certain set of rules and decisions. But it's not, which a contract can do as a written agreement, but they're not the same thing. So when you're contracting in an NFT marketplace, it's important to actually have real contracts, legal contracts, because just relying on the technology and the smart contracts likely is not going to, on its own, be considered a sufficient standalone contract. And I think one of the most important things is to make sure that you're clearly delineating who owns what IP and what IP rights are being granted. And we'll talk a little bit more about this on the next slide, which is covering IP, because a lot of what people do with NFTs may not be clearly defined in the regular terms of use. And we've seen a lot of situations where people are doing all kinds of things with NFTs, and then the terms of service or the governing contract really is not that detailed about what they can or can't do. So I think, as a seller in particular, and also as the marketplace provider, it's worth, at least from a legal standpoint, thinking about, exactly what you want to say contractually people can or can't do with NFT or do on your marketplace, and then codifying that in an actual, terms of use or agreement with the user. And I think that, really takes on a more significant layer of urgency with the multi-platform nature, which we talked, the multi-party nature, which we talked a little bit about earlier, how there are just so many different parties transacting on the marketplace and at such a large volume. So every day, there's probably at least thousands, if not more, transactions happening, for example, on OpenSea. So at that volume, it does become quite important to have a good framework from a legal standpoint, because it's not just one or two transactions that are happening, it's really tons and tons of transactions are happening. You want to make sure that you have the right terms and the right protections in place. And then separately, the multi-platform nature of the NFT space is also a reason to make sure you have good contracts in place and very clearly delineate what the rights are. Because a lot of times, Louis touched upon this a little bit in the previous slide. Even an NFT marketplace provider is not vertically integrated in that they're able to provide every single, service that they're providing. They have to contract with wallet providers. They might need to contract with KYC compliance confirmation services. They might need to contract with payment processing or wallet processing, I guess, the equivalent. And there could be other partners that tools they have to leverage. And this is not like a NFT specific thing. I think any marketplace, and even just, any sort of user oriented platform these days, there's just a lot of multi-platform collaboration that's being required, like different integrations with different platforms, right? So, and that's not specific to NFTs. That's happening generally now in SaaS and in Silicon Valley. So the multi-platform nature of the entire model does, mean that these platforms have to allocate risks between themselves as they're providing the service to the end customer or the end user in this case. So making sure that those agreements are clearly delineated in addition to your agreements with the end user, and in this case, the buyers and sellers on the platform. That's going to be increasingly important, just because with the multi-party and the multi-platform nature, a lot of legal risks that would normally be relatively contained if it were just, a few transactions, they do become exponentially more material in this context. And then lastly, the last thing I'll talk about on the commercial contracting considerations is enforcement issues. So even though you might have a solid agreement in place, going back to the multi-party and multi-platform and high volume nature of the marketplace, enforcement can be a challenge. Being able to track ad behavior and take it down appropriately. And we've seen other user driven platforms have trouble with this, like Facebook, TikTok, like all of those content platforms. So we expect NFT marketplaces to also see challenges in enforcement, just given, first of all, the volume of transactions, and then for NFTs, they kind of have another layer where there's the blockchain, and that can, make it difficult to identify bad actors. In particular, if you're talking about NFT marketplaces that are built on different blockchains. Right now, there's not really consistent interoperability between blockchains, so tracking across different blockchains and different marketplaces also presents an additional challenge in this space. Okay, and then moving to insurance, which is the liability side of contractual risk. We've also seen, people have come to us with questions of how they might buy insurance or underwrite insurance for NFTs or these NFT projects that they're engaging in. And so far, I would say, there have been some insurance providers who have developed a framework as it relates to cryptocurrencies, but we haven't really seen a specific framework emerge with NFTs. And then the NFTs, underwriting likely will be a challenge just because there's a lot of price volatility, both through the underlying cryptocurrency, but also just the value that the NFT itself is being valued at. It fluctuates a lot. And then, the potential for cybercrime, scams, and other bad acts. We've started to see that happen, but the full scope of what is possible there, I think we still haven't, that's still emerging. So I think for insurance providers, they're probably having issues with underwriting because it's hard to determine valuation for these NFTs and the corresponding risk. So hopefully we'll see more guidance or standards emerge around that. Another area that we could start to see some sort of risk protection is through consumer regulation, which so far we haven't seen much of yet, at least in the US. Or we could potentially see self-regulation, which is what happened with eBay and PayPal. They took a more proactive role back in the day, managing, or I guess like taking more of a governing role in bad acts on their platform. So it's an open question whether OpenSea and other platforms will want to step into that role, but those are some areas where we can start to see some structure emerge around risk mitigation and consumer protection. And then moving on to intellectual property. So I touched upon this a little bit in the previous slide under commercial contracting and talking about licensing of IP rights. But intellectual property really is kind of a bigger concern legally with NFTs, because a lot of times the underlying asset, which is a work of digital art that the NFT represents, there could easily be copyright and trademark issues associated with it. So if you're talking, NFT of a musical piece, NFT of an artwork, of an existing, movie clip, things like that, people probably own that registered copyright. And we've seen, for example, lawsuits that are happening right now because NFTs have been minted on existing copyrights that people feel that they're the owner of. They feel like they should get a cut of the NFT proceeds. So I think we'll start seeing more of that. And trademarks are a similar concern, right? If you're minting something with someone else's trademark in the underlying content, that could lead to trademark infringement issues. And I think as an NFT platform, it's important to shield yourself as the marketplace from this type of liability. So we've seen most NFT marketplaces register for the DMCA safe harbor registration from copyright infringement and delineate takedown methods and other ways for users to identify copyright infringement that they'll then, take down pursuant to requirements under DMCA in order to avail themselves of the registration. And I think for creators who are putting their artwork on these platforms, a lot of times, if you are thinking about art or things like that, you could consider if there's a fair use exemption under copyright or trademark law, a transformational work, for example, or if it's a nominative reference. There are just different ways in which artwork or digital art could incorporate trademarks or existing copyrights, but not be considered copyright infringement. But so in addition to the non-infringement piece, as mentioned, and this is obviously going to be embodied in the commercial contracts containing the licenses to the various underlying assets and IP assets, but really clearly delineating what license rights accompany the purchase of the NFT. The most common framework we've seen right now is that the NFT is accompanied by a display and personal use license to the underlying asset. But as the application of NFTs evolve, we might start seeing this accompanying right expand. So for example, the Bored Ape Yacht Club NFTs, right? Like the purchasers of those NFTs are able to create merchandise, they're able to commercialize the NFT for themselves. So with that use model and use case, we might start seeing the scope of licenses that are being granted with those NFTs. Instead of just being something that you can display for yourself, it might be something broader and include commercialization. And I think the other few points we'll touch upon is if you are, especially at the creator and seller level, involving multiple parties to generate an artwork that you're then minting into an NFT, it's going to be important to clearly document who owns that and ownership transfers. We've seen different models emerge where potentially people want to fractionalize revenue streams coming from a resultant artwork. And that's going to, being really clear about how you're documenting that versus the ownership, that's going to be important. Because, at the end of the day, you don't want to have an unclear ownership of the underlying asset of the NFT, because that's really where you could see a lot of disputes and litigation. And then lastly, on patentability, we had Fully NFT Task Force did a webinar on legal issues, and this was one of the ones that we had touched upon in more detail. So I won't talk too much about it here, but there are different methods, different UIs, algorithms you could patent for NFTs, especially if you're a marketplace provider. This could give you a competitive edge. So, anybody who's interested, encourage you to check out our webinar. You can also talk to a patent attorney to get more guidance on this, but this is another area where businesses could gain a competitive edge. And then privacy considerations for NFTs. So this is the other area of legal considerations we'll talk about. And so just to start off, hopefully everybody in the audience knows, but if you don't, it's good to just set the stage that privacy law usually regulates or always regulates personally identifiable information, in some cases household information. So when thinking about NFTs, the question we really should start with is, what would be potential categories of PII that would be regulated and that would be relevant. And so for NFTs, it's more, I would say it's more indirect PII, because there's not really names and emails and social security numbers or credit card numbers that are being disclosed and shared as might be in a different business context. So when we're talking about NFT transactions, the different types of PII that are emerging or that we've seen are online identities and avatars. Sometimes these will be identifiable to the individual, sometimes they won't. The underlying content of an NFT asset. So I think for one of our webinars, I had minted a headshot of my colleague. So that would definitely be considered PII because you can tell it's his picture, that's the NFT. But other NFT assets may not contain content that's able to identify an individual. So that one's also one where it could be PII, but it could also not be PII depending on the circumstances. Same with blockchain addresses, depending on how people are naming themselves and what the address is, could be considered PII. Transaction activity, location data, this is more, if taken as a whole, you might be able to, especially from a chronological standpoint across a period of time, you might be able to identify the individual from their activities or the different locations that they're visiting. So those are the different types of PII that would be relevant in the NFT context. I would say generally, these are not as high profile as some of the other types of PII that are regulated by privacy laws, in particular, like health information, sensitive information. So it's more kind of, there's a potential for PII to be included in an NFT transaction, but not always will that be the case. And then from a regulation standpoint, we've really seen that the blockchain and the NFT transactions contain some inconsistencies with prevailing data privacy laws. For example, prevailing data privacy laws generally provide data subjects with the right to amend, access, or correct their information. And this really conflicts with the immutable nature of a public blockchain. So for example, if you were to mint your PII onto a public blockchain, perhaps, with a headshot of yourself or something like that, and you want to change it or take it down, and that NFT linking to your headshot is now owned by somebody else, there would not be like a central place where you could exercise that right, which is what's normally expected under prevailing data privacy law. So that's kind of a inconsistency that hasn't really been resolved at a regulatory level. There's also I don't know if inconsistencies is the right word, but just potential areas of infeasibility around applying the data privacy laws, because a lot of data privacy laws are territorial, and a lot of it comes, with respect to where is the data subject a resident of, where is the controller of that data, who's collecting that data, where are they established. And the blockchain, in contrast, is more global and it doesn't have clearly defined jurisdictional bounds. So that's going to be another challenge in applying existing data privacy laws to this new technology. And then going back to what I said about, who's the controller, that's really the concept under GDPR and other emerging data privacy laws in various jurisdictions like Brazil, California, China even recently. The controller is really the responsible party for the data that they're collecting and then sending off for processing. In the blockchain with the different parties, it's really hard to identify who the controller is because there's not a centralized body that's collecting that information. The distributed nature necessarily means that all these different parties are doing things on the blockchain. We have some guidance from the CNIL, the French data protection authority, that indicates they believe that participants who have full writing rights on the blockchain to be able to send that data to miners on the blockchain for validation, they would consider them to be controllers. So we'll have to see where the regulation evolves in that sense. But short of it is, I would say data privacy is not the most pressing risk of harm right now. With the NFTs, there's just so much more on the security side, on the IP side, on the bad use, bad actor side, that I don't think data privacy has really been a regulatory focus, just because we've seen other more material risks of harm emerge on this technology that people are focusing on. So that takes us to our next slide, which will talk about where things are headed, especially in this space and based on what we've seen. Louis, I'll turn it back to you to talk about this.
Thanks, Catherine. And it's a great segue. Where are we heading? And obviously, we think that the SEC has a lot of things to do to help stimulate and properly regulate this market. I think unhelpfully, we saw a proposed rule change to 3B16 under the Exchange Act that would purport to pull in all of these marketplaces within the regulation of exchanges. And look for a post from Foley and Lardner on that new proposed rule that came out from the SEC last week very shortly. These kinds of developments we think are very, very unhelpful. As you structure your marketplace, however, you're really going to think, okay, how do I make sure that what I'm building is not a security? How do I make sure that the marketplace where I'm selling my non-fungible token is not an exchange? How do I make sure that my smart legal contract is drafted and coded in the most helpful fashion? How do I make sure that I am not a money transmitter? And these are all things that require building a great team and having great advisors. And as we look forward, we think that more and more businesses are going to look to monetize the non-fungible content that they have and really take advantage of the blockchain to do that. And lawyers like Catherine and I are here to help demonstrate how other entrepreneurs have done it, what we've seen, what's worked, what hasn't worked. And really, I think it's about building great relationships and great partnerships across the ecosystem to succeed. What advice you have for entrepreneurs as they seek to monetize non-fungible content?
Yeah, I think I would agree with what you said, Louis, about kind of building that network, because a lot of it, going back to what we talked about, multi-platform and multi-party nature necessarily requires you're not going to be vertically integrated. You do need that network in order to scale. So definitely I would agree with that. And I would just add that from a risk protection standpoint, entrepreneurs who are heading into this space, it's definitely worth early on, talking to an advisor, getting some basic risk mitigation strategies in play, just because it is a gray area. Even like Louis mentioned, we're just seeing guidance this week and continuing to see very real-time guidance from regulatory bodies like the SEC. And there could be other ones that get involved as this progresses. And you don't really want to be, the first guinea pig that they decide to bring down the regulatory hammer on. So it's good to at least consider compliance and risk mitigation, because it is kind of, I would say, a space with higher regulatory risk, just because so much of it is new and undetermined.
Yeah, and I would advise that entrepreneurs work with full service law firms that are really focused on the space. Here at Foley and Lardner, we saw this coming a long time ago and built an NFT task force of interdisciplinary lawyers that come from IP backgrounds, privacy backgrounds, with industry vertical expertise to bring the combined knowledge of the platform to bear for the benefit of the enterprise. And I think having world-class accounting advisors, security advisors, and finally tax advisors is also critical. I think we've covered the material we wanted to cover, and we've got a lot of questions in the chat box, Catherine, for us to look at. And I think the first one comes from Malika Ewart, who's asking, can one simply take a screenshot and turn that into an NFT? Do you want to take that, Catherine?
Sure, yeah. So yes, you can typically screenshot an NFT, but I would just say the existing analogy to really think about is you can take a photo of the Mona Lisa, but that's not going to be the same. You can even have someone recreate a replica of the Mona Lisa, but it's not going to be the same as owning the Mona Lisa. Same for a Birkin bag. You can have, some factory create a look-alike of the Birkin bag, but it's not going to be the same thing as owning a Birkin. So when you're thinking about NFTs in a collectibles context, I would say that's really the way to think about it. Even though it is a JPEG, you can just download it, reproduce the JPEG. It's really the ownership, the unique ownership of this particular digital asset that attracts people and gives it the high valuations that people are paying. And not everybody is going to understand that. And I'll be the first to say that I may not be able to relate to it. I also can't relate to like paying $50 million for a particular painting, but people do it. So it's really about, the ownership and the collectible piece that people are relating to and engaging with when they're purchasing, at least in a collectibles context, these NFTs for large sums of money.
We've got another question from Allison Stone about the circumstances by which a marketplace would be required to become a national securities exchange. And Allison, my comment there was that if a token is a security and it is listed in a marketplace, and that security is being, and the marketplace is offering bid-ask prices for initial sale and resale of that security, that marketplace would have needed to be a national securities exchange, which is a lengthy and complex registration process, or it would need to be a registered alternative trading system or some other regulated entity, and none of the various marketplaces are, and so that would be a big problem. Next, we have a question from Juan Gonzalez. Would the fact that the smart contract includes the required terms of a contract in itself make it a binding contract, especially where those terms included are an offer, acceptance, and consideration for the NFT? So, Juan, thank you for reminding us of what are the elements of a contract. That's an offer, acceptance, consideration, and specifically enumerated terms. And yes, all of those items need to be coded in to the smart contract in order for it to be binding. Next, we have a question from Robert Bowles, whether we think, or what do we think about a platform that would help identify authentic items with NFTs but are not connected with the actual underlying company of the asset that are being authenticated. And I think where this is going, Robert, is that there are whole cottage industries of vendors that are coming forth to play a critical role in the value chain of monetizing content by minting them on NFTs. And so authentication could indeed be a vendor that would help. Privacy is an area where we've seen this come into play. There's a company called Civic, founded by Vinny Langham, that's famous for this. And I think that takes us to the end. Once again, it's been just a pleasure for my good friend and colleague Catherine Zhu and I to address your group today on how to create and how to mitigate legal risk when creating an NFT marketplace.